This video is about helping tenants who are having trouble getting their landlord to make repairs. Unfortunately, this is a common problem, and there are some common misconceptions about the best ways to deal with it. This video is intended for attorneys who have limited experience with these kind of cases. Non-attorneys may find it useful as well, but we recommend reading through the rest of the material in this online classroom first. A tenant's right to live in decent, safe, and sanitary housing is often called the warranty of habitability. Many states have adopted an implied or common law warranty of habitability, but South Carolina has not. Our Supreme Court confirmed this in Young v. Morrissey, holding that in the absence of an express warranty, a tenant generally takes the property as is. Young is still good case law in South Carolina, at least to a point. In 1986, the General Assembly adopted the South Carolina Residential Landlord-Tenant Act, a version of the Uniform Residential Landlord-Tenant Act drafted by the Uniform Law Commission. It applies to residential tenancies where the rental agreement covers a dwelling unit. A rental agreement does not have to be in writing, and the Act defines dwelling unit very broadly. The warranty of habitability is codified at South Carolina Code Section 2740-440. Like South Carolina, many other states have adopted versions of the Uniform Residential Landlord-Tenant Act, and while most of these have made changes to the Uniform Act, case law from these states may prove persuasive in South Carolina. Some situations that might look like residential tenancies are specifically excluded from our Landlord-Tenant Act, so there would be no warranty of habitability unless the parties agreed to it or other law required it. Some of the most common exclusions are residence at a public or private institution, which is incidental to detention or medical, geriatric, educational, counseling, religious, or similar services. For example, there's no warranty of habitability in prison. But remember that a situation is not excluded just because some other service is being provided. Occupancy must be incidental to the provision of that service. Occupancy under a contract of sale is also excluded. For example, rent-to-own agreements may fall under this exclusion. Transient occupancy in a hotel, motel, or other accommodation subject to sales tax under South Carolina Code Section 1236-920. Occupancy by an employee of the landlord whose occupancy is conditional on employment in and about the premises. Timeshares, emergency protective shelters, leases for land only, or commercial or other agricultural leases are all excluded from the South Carolina Residential Landlord-Tenant Act. The Landlord-Tenant Act specifies some things that a landlord has to do in order to comply with the warranty of habitability. For example, a landlord must make running water, hot water, and reasonable amounts of heat available. There's also a presumption that any facilities or appliances that are in the unit must be maintained by the landlord. To get around this, a landlord has to specifically exclude them in the lease. Anything that is needed to provide what the Landlord-Tenant Act deems essential services cannot be excluded, so the landlord always has to maintain them. A landlord has a general duty to put and keep the property in a fit and habitable condition. There is very little case law in South Carolina that offers guidance as to what this means, but case law from other states which have adopted versions of the Uniform Residential Landlord-Tenant Act, like South Carolina has, may be persuasive, and we'll review some shortly. The Landlord-Tenant Act also refers us to applicable building or housing codes, and requires a landlord to comply with them to the extent that they materially affect health and safety. These codes can be a good place to find guidance as to whether a particular problem violates the warranty of habitability. Here are a few examples from the 2012 International Property Maintenance Code. Many cities and counties have adopted versions of the International Property Maintenance Code in their ordinances. Sometimes only parts of the code are adopted or changes are made, so you'll have to check in your local jurisdiction. These codes provide much more detail than the Landlord-Tenant Act about the condition a structure must be kept in, so they can be very helpful in proving a violation of the warranty of habitability. The Landlord-Tenant Act uses the phrase materially affecting health and safety in several places, including the section requiring landlords to comply with applicable building or housing codes. The failure to comply with such a code doesn't violate the warranty of habitability unless the code at issue materially affects health and safety. Of course, it's not always clear whether a problem rises to that level. While we would often look for appellate decisions for guidance, there are relatively few reported cases on landlord-tenant issues in South Carolina. A couple of those cases are cited here, but the rest of those listed come from states that have adopted a version of the Uniform Residential Landlord-Tenant Act. They may be persuasive for that reason. Here are some more examples. If any rule can be drawn from these cases, it's that two things will often prompt a court to find that a problem materially affects health and safety. One, when the problem affects essential services like plumbing, electricity, gas, hot water, or heat. And two, when the problem affects appliances that supply important services, and the landlord has an obligation to maintain those appliances. There are also problems that courts tend not to find that a landlord is responsible for. The clearest example from South Carolina law is that a landlord usually doesn't have an obligation to protect tenants against the criminal acts of third parties. Other states that have adopted versions of the Uniform Residential Landlord-Tenant Act offer other examples. If there's any rule to be taken from these cases, it's that the criminal acts of third parties and things that were permissible under building codes in effect at the time the dwelling was built probably will not trigger landlord liability. Now that we have a sense of when the warranty of habitability applies and what it covers, let's talk about how to enforce it. We've talked some about problems that materially affect health and safety, and while those kinds of problems will usually violate the warranty of habitability, it may not be necessary to prove that a problem is that severe. The Landlord-Tenant Act gives a tenant the right to certain relief for any non-compliance with the rental agreement or with the warranty, and at least one court in a Uniform Act state has been clear that breaches need not be material or involve essential services in order to trigger the tenant's right to relief. However, the seriousness of the problem affects the damages a tenant is entitled to and may determine whether it's worth bringing a habitability case at all. It may go without saying, but it's important that a landlord be notified of the problems and given a chance to correct them before a tenant sues. How much time a landlord has to be given depends on the remedy the tenant is seeking and how serious the problem is. We'll get into that in a little bit more shortly. It's also important to remember that a cause of action for breach of the warranty of habitability sounds in tort, and a tenant is not limited to recovering contract damages. As with many causes of action, there are two ways a habitability claim can be raised. First, the claim can be raised affirmatively in a suit for damages and/or injunctive relief. This route is preferable for the tenant, though it seems to be taken less often. If the tenant files an affirmative claim, they can choose when to file and have some control over the pace of the action. In some cases, they also have the ability to choose the forum. For example, if the tenant has a claim to damages in excess of $7,500, and if they don't want to waive that excess, then the magistrate's court would not have jurisdiction and the case would need to be filed in circuit court. There, the tenant has access to discovery, and the forum may offer some other advantages. Second, habitability claims can be raised defensively after a landlord has filed for eviction. This seems to be the most common way that habitability issues are raised, but the tenant is at a relative disadvantage when these claims are raised defensively for several reasons. First, eviction cases can move very quickly, and it can be difficult to prepare a habitability defense in the time allowed. Second, tenants who raise a defense or counterclaim in an eviction case are required to pay rent as it comes due after the case is filed, and they must also pay any rent that the landlord alleges was due before the case was filed. If there's a dispute about this amount, the tenant can ask for the judge to hold a hearing and make a preliminary decision about what's owed. The Landlord-Tenant Act says that the rent owed should be the fair market rental value of the unit at the time of the hearing. While a tenant can try to prove that the fair market value is less than what he's been paying because of the landlord's failure to make repairs, this can be difficult to do on short notice. If the tenant fails to pay whatever the courts decide is due, or is more than 5 days late with any payment, they're subject to summary eviction. Finally, if the tenant raises a habitability defense or counterclaim in an eviction case, the magistrate's court has jurisdiction even if the tenant's claim for damages exceeds $7,500. As a result, the tenant can't get the case into circuit court and does not have access to any formal discovery in magistrate's court. This can also make it difficult to prove the defense or the counterclaim. Probably one of the main reasons why tenants end up raising these claims defensively is that they will often withhold rent when their landlord is not making repairs. Doing this makes sense intuitively. The tenant believes that the landlord isn't doing their job and feels like that excuses the tenant from doing theirs. Some states explicitly allow a tenant to withhold rent under some circumstances, and while it's not specifically prohibited in South Carolina, it usually puts the tenant in a worse position. Now, let's go into a little more detail about how habitability issues can be raised affirmatively. The Landlord-Tenant Act offers a tenant 3 remedies for a breach of the warranty of habitability, but the tenant can't choose them all. Instead, the tenant needs to decide very early on whether they want to stay in the home and try to force the landlord to make repairs, or whether they want to terminate their lease and move out if their landlord refuses to do so. A tenant can recover actual damages regardless of which option they choose, and can recover attorney's fees if the landlord's failure to make repairs was willful. Whether to stay or go can be a difficult decision and should be based on careful consideration of several factors. Each case is different, but there are a few things that come up in most cases. First, consider the severity of the problems the tenant is having. The tenant only has the option to terminate their lease and move out if the problems materially affect health and safety or the physical condition of the property. The cases cited earlier in this presentation may help in deciding whether that's the case. Also, in some situations, the needed repairs may be so costly that the landlord is unable to make them. Sometimes completing the repairs would mean that the home is uninhabitable for quite some time. It's important to make an honest assessment of whether going to court and getting an order saying that repairs must be made will be a practical and efficient remedy for the tenant. In addition, consider whether the fight over these problems is likely to be repeated later. Sometimes the problem you see now is only just the tip of the iceberg. On the other hand, sometimes there are factors that weigh heavily in favor of staying. For example, if the tenant is living in certain types of affordable or subsidized housing, they may not be able to move out without losing their housing subsidy. A tenant may also not be able to move as a practical matter due to the cost, and there may be other compelling reasons to stay, such as proximity to school, work, or family. When a tenant decides that terminating their lease is the best option if their landlord continues to fail to make repairs, the first step is sending a written notice to the landlord, which says what the problems are and tells the landlord that if they're not fixed within 14 days, the tenant will consider their lease terminated and move out. It may be best to have the tenant send this letter because, if necessary, they can testify about having done so. There is a form letter that you can use for this in the materials section for this classroom. It's important to remember that a landlord has, at minimum, 14 days to make the needed repairs before a tenant can terminate their lease. If the repairs are made in that time, then the lease does not terminate, and the tenant cannot move out without risking liability for rent or other charges. If the problem is serious but does not affect health and safety, and if the repairs can't be completed within 14 days, the tenant may still not terminate their lease as long as the landlord pursues repairs in good faith and completes them within a reasonable time. If the repairs are not completed within 14 days, or within a reasonable time as we discussed, then the tenant doesn't have to do anything other than move out. However, it may be beneficial to consider a couple of options that can help get the tenant more complete relief and help protect the tenant against action by the landlord in the future. The first option involves filing an action after the tenant has moved out to recover any damages they're entitled to. It usually makes sense to try and resolve any security deposit issues in this action as well. So you should consider having the tenant send a security deposit demand letter when they move out. If the landlord fails to return the deposit within 30 days after the lease ends and the tenant moves out, or if the landlord withholds amounts from the deposit that are not justified, then those claims can be raised as well. There's a sample letter for demanding a security deposit in the materials section of this classroom. The second option involves the tenant filing an action to have their lease declared terminated before they move out. Now, I've marked this option experimental because while I believe it could be a good option in the right case, I have not had a case where it made sense to do this. Generally, it seems that by the time the tenant is prepared to file a lawsuit in order to get out of their lease, the problems are so serious that they don't want to stay in the home a moment longer than necessary. That said, in the right case, it could offer the tenant an assurance that they have the right to break their lease before they actually commit to doing so. If the tenant has chosen to stay in the home and try to force the landlord to make repairs, then the process, if not the practice, is fairly straightforward. First, the tenant needs to give the landlord notice of the repairs that are needed. The Landlord-Tenant Act does not require that this notice be in writing or even that it be given by the tenant. All that's required is that the landlord have notice of the need for repairs. However, it's probably a safer bet to have the tenant give the landlord a written notice saying that a lawsuit will be commenced if repairs are not completed within a certain time. Also notice that the tenant is not required to give the landlord any particular length of time to complete the repairs before filing an action seeking injunctive relief. Generally, it may be best to give 14 days because a court may look to other parts of the statute to determine what a reasonable length of time is. However, there may be situations where waiting that long could cause the tenant some serious hardship. In those situations, a shorter period of time may be justified. If the problems are serious, it may also make sense to ask for a temporary restraining order or preliminary injunction so that the tenant does not have to wait for a landlord to answer and a trial to be scheduled, a process that can take quite some time even in a summary court. There are sample pleadings for this in the materials section of this classroom. There's another claim you may want to consider if the landlord's failure to make repairs has caused an interruption of essential services. The conduct that causes the interruption needs to be willful as defined by the Landlord-Tenant Act. However, if the claim is successful, the tenant can recover 3 months' rent or twice their actual damages, whichever of those is greater, along with attorney's fees. While it's usually better for the tenant to raise habitability issues affirmatively, it's probably more common for those issues to be raised as a defense or counterclaim in an eviction case. There are two things that most often trigger an eviction filing when there's a repair issue. The first and most common is when the tenant withholds rent in an attempt to coerce the landlord into making repairs. Instead of getting repairs made, what happens more often is that the landlord files for eviction, alleging non-payment of rent. The second is when a landlord files for eviction as a way to retaliate against the tenant for making complaints. While this is less common, it does happen. In either case, the tenant may have a defense or counterclaim that should be raised in the eviction case. The Landlord-Tenant Act expressly allows a tenant to raise counterclaims in an eviction case when the landlord alleges non-payment of rent. But the landlord has to have notice of the need for repairs before the rent that's at issue in that eviction case comes due. If the repairs don't involve essential services, the landlord has to have notice at least 14 days before that rent came due. If essential services are involved, the period is shortened and the landlord only need have a reasonable opportunity to make emergency repairs. This section doesn't expressly give the tenant a right to withhold rent, but it does deal with that situation indirectly by opening the door for a tenant to counterclaim and argue that the rent that the landlord is claiming isn't owed in the first place because the landlord's failure to make repairs has caused as much or more damage to the tenant than the value of the unpaid rent. While probably less common than filing for eviction after a tenant withholds rent, some landlords will retaliate against tenants who complain about the need for repairs. The Landlord-Tenant Act defines retaliation as raising rent beyond fair market value, decreasing essential services, or filing for eviction. To be actionable, the retaliation needs to be for certain protected conduct, which includes complaining to the landlord of a violation of the Landlord-Tenant Act, or complaining about a violation materially affecting health and safety to any government agency responsible for enforcing building or housing codes. A landlord who retaliates in this way is liable for up to 3 months' rent and attorney's fees. If you raise habitability issues defensively, there are some things that you should be prepared for as they often come up. The first is the requirement that a tenant who raises defenses or counterclaims continue to pay rent while the case is pending, and that they pay any past due rent that the landlord alleges is owed. Failure to do this can mean an immediate eviction judgment. If there's any dispute about the amount of rent the tenant should be paying, the court is supposed to hear the issue and make a preliminary determination as to what the fair market value of the property is. The tenant should then be required to pay that amount as the case goes forward. Presumably, that amount would also apply to any back rent that is due. Courts have different approaches to this requirement, and often the issue doesn't come up unless the tenant requests a jury trial. Cases often come up for bench trial so quickly that it doesn't make sense to set a preliminary hearing, and most courts will address all issues at once. Practically, if the amount of rent the tenant should be paying is in dispute, it may make sense to request a hearing to determine the rent amount in a responsive pleading, and a sample answer and counterclaim is in the materials section of this classroom. There are a couple of misconceptions about tenants withholding rent that seem common enough to bear mentioning here. The first is the idea that a tenant simply isn't allowed to withhold rent. The problem with this notion is that the Landlord-Tenant Act says no such thing. While the Act doesn't expressly endorse a tenant withholding rent, it doesn't prohibit a tenant from doing so either, and actually seems to assume that a tenant can withhold rent and then use the landlord's failure to make repairs as a defense or counterclaim, as long as the landlord had notice of the need for those repairs before the rent came due. The second misconception is the idea that a tenant has to file an action before they withhold rent. The Landlord-Tenant Act seems to allow this as a form of injunctive relief that a tenant can seek under Section 2740(6)10. However, nothing in the Act says the tenant has to file first. The only direct reference in the Act to rent abatement for failure to make repairs is in 2740(790), which deals with what happens when a tenant raises defenses or counterclaims after a landlord has filed for eviction. So, while a tenant could file first, they don't have to, and the Landlord-Tenant Act appears to sanction either route. Landlord-tenant court is not mysterious, but there are some peculiarities as with any area of practice. Here are a few tips that may prove helpful in handling habitability claims. Having a tenant send various notices to their landlord makes them available to testify about having sent the notice should that be in dispute later on. A demand letter from an attorney can sometimes aid in resolving a case, but you may want to consider sending one in addition to a notice sent from the tenant. Getting or staying current on rent gives the tenant more options and is usually the best practice. Pictures or video of what the tenant is complaining about can be very persuasive. And in some cases, an inspection by code enforcement or the fire marshal can be very useful to determine whether the problems are health or safety issues. You may also be able to have them qualified as experts and offer opinion testimony on this point. However, a word of caution. If the problems are very serious, code enforcement or the fire marshal may take the position that the home needs to be condemned and that the tenants need to move out very quickly, and that may be true in some cases. However, moving quickly may be a hardship for the tenant, and it's best to discuss this possibility with them beforehand. You may also want to contact code enforcement before calling them out for an inspection to get a sense of how they will approach the situation. If you're asking for injunctive relief, for example, like an order requiring a landlord to make repairs, consider asking for a penalty for noncompliance. A dollar amount per day of noncompliance is one option. If you're settling a case with a landlord, particularly if the tenant is going to be moving, consider asking that the landlord give a positive or a neutral reference. A negative reference can limit a tenant's options and may make it difficult for the tenant to move at all. Remember that there are numerous fee-shifting provisions in the Landlord-Tenant Act, and these can make it feasible to take cases for tenants who could not otherwise afford legal help, and a list of a few of those are at the bottom of this slide. Thanks for watching. We hope that this information has been helpful and that it encourages you to help tenants with these all too common issues. If you have any questions or if you're interested in signing up as a contract attorney with our PAI program, please feel free to give us a call.